Let's talk about the mechanics of getting the voluntary departure. It used to be easier. It's not easy anymore.
Yes. And you can get, before the immigration judge takes testimony of anything on your application, and it could be pending, you don't have a final hearing yet, no testimony is taken, you walk into court and you say, Judge, I don't even want you to hear it, just give me voluntary departure. Judge can give you up to 120 days, which can be useful to prepare to depart. At the end of the testimony, if you notice things didn't go very well, you can still ask before the judge hits the hammer saying, deport. You can still ask for voluntary departure, but only up to 60 days. Now, in both cases, you have to have good moral character, means no major criminal stuff. And also you have to demonstrate, if I give you voluntary departure, you have a valid passport, for example, you actually have the money to buy a ticket. And in most cases, if you know that's what you're going for, you go with the itinerary, showing your flight, destination, etc.
So you're going to ask when and how. Here's what we do for clients in the scenario that we're talking about right now. We try to time your voluntary departure to the point where your other visa may be available. For example, if you're in a labor certification process and there will be a green card coming, if you have a potential to do an L1A later, if you are waiting for your EB2 visa and IW being approved, there's all kinds of circumstances. We don't necessarily want the voluntary departure immediately. We sometimes wait so that you can stay in the U.S. to the very final moment when your visa or your green card is available. Then you get the voluntary departure. You have 120 days to leave. You leave, get your appointment with the consulate processing, and come back. In fact, we now have attorneys in the office who have worked with consulate processing. They've been consular officers. They've been USCIS attorneys. And we try to understand the USCIS and the consular processing mentality by understanding what these attorneys have worked through so they can use their strategies now helping our clients get their consular processing done successfully and coming back to the United States. Make sense?
You raised a really important and really wonderful thing to talk about. If you have current process, for example, you're going for a green card for employment, EB, you can take this all the way up to when you look at the chart and you know your visa will become available, and you can leave because if you have 120 days, you can plan it out. But when you go to the consulate, okay, they cannot talk about any of this other stuff. We're in deportation proceedings. They cannot. They will just look at one thing. Do you have any bars that are criminal, for example? Do you have any bars that are fraud? Did you commit any fraud? They can look at unlawful presence, but as we said, if you have a pending asylum application, don't accrue anything.
Right.
So you go out there, you consular process, and within months you're gone.